Well, let's go to the main story of the day now. A scathing Constitutional Court judgment against Public Protector Advocate Busisiwe Mkhwebane, sparking renewed calls for her to be removed from office. Mkhwebane lost her appeal against paying a punishing costs order issued by the North Gauteng High Court. In setting aside her report on the Reserve Bank and the Absa Bankorp matter, the judges held Mkhwebane personally liable for costs. They amount to just shy of R1 million. Joining me on the line now is the Chief Whip for the Democratic Alliance, John Steenhuisen. John, good evening to you. Thank you for your time tonight. Obviously, you saw the judgment today. Do you believe the Public Protector should now be removed from office?
Well, I think that after a scathing judgment like that by the highest court in the land, the very court that's to uphold the very constitution you're a Chapter 9 head to uphold, I think the honourable thing would have been to tender your resignation. Obviously, Ms. Mkhwebane intends to tough it out, and therefore I think that the nature of the judgment today, the scathing nature of the findings, the egregious findings against the Public Protector, now have to force Parliament to conduct an inquiry into a fitness to hold office. It's going to be very, very difficult for Parliament to simply turn a blind eye to a judgment of this nature by the highest court in the land. And I think it puts Ms. Mkhwebane back in the firing line in terms of Parliament.
The Public Protector's Office confirmed again this morning that she has written a letter to the Speaker in the National Assembly, Thandi Modise, saying that she would go to court if Parliament were to move against her because there are not proper procedures in place for such a situation to occur. In other words, for that removal to happen. Do you believe that could protect her or could stop this process from happening?
No, and I think it's saber rattling on behalf of the Public Protector, who's obviously now trying to stem and push away any potential move against her. The Constitution is clear. Parliament can create its own internal procedures and policies about how it conducts its business. That is a constitutional provision. And therefore, whatever procedure Parliament adopts, provided it's fair and open and gives her an opportunity to put her case, I believe is a proper procedure. The framers of the Constitution envisaged a situation where you would have a Public Protector that was A, no longer able to perform the task, or B, had become a constitutional renegade, as we see in the case of Mrs. Mkhwebane. And that's precisely why they allowed for Parliament to be able to initiate removal procedures against her. I think she's trying to scare Parliament off, and I certainly hope that the Speaker is going to hold her resolve and do what Parliament needs to do in this instance, which is to hold Mrs. Mkhwebane accountable.
Okay, at the same time, we have, of course, the statement from the President last night, President Cyril Ramaphosa, his response to her findings against him and his ANC leadership campaign. That was a complaint that was lodged by the Democratic Alliance, your party. Do you believe that her finding on that score should fall away?
Well, I think each report has to be judged on its own merit, but I would go so far as to say that her remedial action as it relates to Parliament is completely bizarre. She's essentially wanting the President to appear before the Joint Ethics Committee when the President is not a member of Parliament. It's just probably one of the most bizarre recommendations I've ever read in my life. I think it blurs the lines between the executive and the legislature. And I think it's going to be very easy for the President to repel that particular remedial action, which calls into question whether the rest of the report is valid. But that's for the courts to test. As the courts tested in this particular Absa Bankorp matter, the Public Protectors appealed it all the way through the courts. Her road has now come to an end in the ConCourt's today, and a very messy end it is. And so whether the President, how far she defends the report that she's putting to the President, remains to be seen. But certainly as it relates to the Absa Bankorp matter, she has a serious case to answer. I think that she sits this evening in a very, very difficult position in defending her tenure as the Public Protector.
The Public Protector found, along with the finding that you've mentioned, also found that the payments that were made to the CR17 leadership campaign in the ANC were a benefit. They amounted to a benefit for the President. If you extend that finding, and many people will, it will lead to a situation where any member of Parliament who then goes through an internal party leadership campaign and receives money should declare that too. That would mean Busisiwe Mkhwebane, for example, should declare any money he received for his leadership campaign. Would the Democratic Alliance favour that?
Well, of course. We already have an internal disclosure mechanism where anyone who raises any funding for any campaign for an internal position in the party is required to declare that to the federal chairperson of the federal executive, and there are some rules around that. But certainly the Code of Ethical Conduct and Procedure, which applies to members of Parliament, and not in this case to the President, is very, very clear about donations and sponsorships and how they should be declared if they accrue to the member in their personal capacity. And so those have to be, and of course now the newly adopted party political funding bill is also very clear about what needs to be declared, even in internal campaigns and the like. So I think that there is an era of accountability that's going to be on us in terms of having to declare these things, and obviously the long-term effects of that on both internal democracy within political parties and on a multi-party democracy remain to be seen. But certainly, those things are already, I believe, disclosable items in terms of the party political funding bill and, of course, the Code of Ethical Conduct for members of the National Assembly and members of the Council.
John, you will be aware of this criticism that's been made of your party in the past. So on the one side, you, as a political party, lodge complaints with the public protector, sometimes for political purposes. Perhaps Busisiwe Mkhwebane, your leader, did in this particular case around the president. At the same time, you're now calling for her to be removed. Surely you can't have your cake and eat it.
Well, Stephen, I think what you have to do is to separate the personality from the office itself. Now, in the instance of misleading Parliament, there is only one avenue of recourse in that instance, and that is by the Executive Members' Ethics Act, and the custodian of that is the Office of the Public Protector. So whilst we certainly believe that Ms. Mkhwebane is unfit to hold public office and that she is the wrong person for the job, the Office of the Public Protector has to be separated, and that, as I say, is the only recourse there. The other point to make is that, you may not like the local station commissioner at your SAPS station. It doesn't mean you stop reporting crime to the SAPS at that station. There's procedures that have to be followed, and the law is very clear what those procedures are. And in this instance, Mr. Mkhwebane followed it, and the office has to be separated from whoever the present incumbent is.
Okay, it's unclear, certainly as I speak to you now this Monday evening, whether there will be a move by the ANC against the public protector in the shorter term. There might be in the longer term, we don't know. If Parliament does not act against her and there is not this kind of hearing, will you go to court to try and force it?
We would have to, Stephen, because I think particularly given this morning's judgment and the very, very scathing nature of it. And the judges did not mince their words. They were very unambiguous about their displeasure with the way in which the public protector has conducted herself and the haphazard and sloppy way in which her investigation was done, as well as the blatant dishonesty from her side in her responding papers and under oath. I think that Parliament, if it was not to act on the basis of that report, it would be unreasonable and irrational for it not to, at the very least, conduct an inquiry. Parliament was already found wanting in the Nkandla matter, the Mkhwebane judgment and that matter, was scathing about Parliament's inaction. Deputy Chief Justice Zondo, just in the last fortnight, has been scathing about Parliament's inaction on state capture. What Parliament cannot be found wanting for now is the hat trick of being found wanting on dealing decisively with a public protector who has clearly become a constitutional rogue and who needs to be reined in.
The Democratic Alliance Chief Whip John Steenhuisen, thank you for joining me tonight. Just to let you know, we have tried several times to get hold of the economic freedom fighters tonight. So far, we do not have a response from them. If we do get a response from them, we'll bring them to you here on The Full View.